first part of my note,
Sir,
and also because...
let's read that. It's important,
Yes,
actually.
yes.
Let's read it.
So, my lords, the first point, the backdrop of the Assam Accord dated 15th August 1985. The Assam Accord was signed between the Union of India, State of Assam, All Assam Students Union, and All Assam Jan Sangram Parishad in the backdrop of a 6-year-long movement, 1979 to 1985, in the state, against the unabated illegal migration of foreigners into Assam, their settlement in Assam, and their inclusion in the voters' list. During the agitation, about 860 persons who are considered as martyrs during the Assam movement lost their lives and thousands were injured due to police action. Very recently, the Martyrs' Day was actually in commemoration of these people who had lost their lives, was held, my lords, in Assam. The state suffered tremendous political uncertainty with 4 changes of government and 3 spells of president's rule during the 6-year period. And this is very important, my lords, clause 13 and 14 of the Assam Accord, because this is on restoration of normalcy, which is the underlying concept under section 6A. That is the purpose it was brought into, for the purposes of restoration of peace and normalcy in the state of Assam. And a book that sums it up, The Quest for Modern Assam by Arup Jyoti Saikia, which is also a part of the compilation. It has 2 chapters on each and every meeting that had gone on that time with the government and with the All Assam Students Union, the run-up till 1983. Thereafter, in 1985, after the Prime Minister's assassination, then in 1985, what were the events which led to the agreement behind this Assam Accord, and then it came into play. And the background that was discovered was also discussed, and when finally agreed upon were the 1964 riots which had happened in East Pakistan, where there was mass massacre of the population, and therefore they had escaped into India. So therefore they became a part of the 1967 electoral rolls. So therefore that part of the population that had come in at that stage was included, but the part after that, then the government agreed, would be kept disenfranchised. Therefore, the period till 1971, where they were not included in the electoral rolls. So therefore, in the history of this entire accord is the agitation, and therefore the difference between West Bengal and Assam for the purposes of this particular section. Now coming to my second point, where a lot of arguments were raised by the petitioners on the infiltration continuing. For that, I just want to point out one para from the reference order itself. Para 46 is very important, because the point that we are making here is that the constitutional vires of a statutory provision cannot be tested on the basis of faulty or inadequate implementation of the said provision. And if my lords will only have para 46 of the reference order, it says, if I may just read the introduction, on an overall consideration of the immediate dimensions of the issues and the potential that the same have for the future, we issue the following directions under Article 142 of the Constitution of India. 1 is border fencing, border roads, and provision for floodlights. The second is foreigners' tribunals. The third is existing mechanism of deportation of declared illegal migrants. And in that, 48.1 preparatory work such as selection of vendor system, development by system integrator, appointment of staff and training, etc., has already been directed to be completed by the end of January 2015 by order dated 27/11/2014 of the court. 48.2, the remaining work of updating the NRC will now conform to the following time schedule, which will be strictly adhered to. And 49, all the cases, so on and so forth. So therefore, if my lords will see that this is the implementation that had to be carried out as per the Assam Accord, the absence of this implementation cannot be a reason to fault section 6A. Then coming to the third point, which has already been addressed, so I will only talk about the case law very briefly to say that the petitioners are also disentitled from claiming the relief on account of inordinate delay. And for that, I only want to point out that whether it is Ram Chandra Shankar Deodhar, whether it is Rabindranath Bose, or whether it is Trilok Chand, the underlying concept in all these judgments is that if the rights of another set of people have already got created, then the delay in filing the petition cannot be then waived off. And my lords will just see, I have just given a few instances when they could have challenged and they did not. And therefore, these rights have now crystallized over 40 years. One instance that I've given, the report by the Lieutenant General S.K. Sinha was prepared on 8/11/98, which in detail talked about this problem.
Then comes that reply to the unstarred question,
Yes,
14
yes.
July 2004.
Absolutely. Absolutely.
And the petition Sarbanan Sonowal, you say, was filed in 2000.
Absolutely. And this actually considers the Assam Accord in para 18 and in para 33 in great detail. The next point, I will just on the legislative competence, I just want to point out one article just for the purposes of saying that how 5, 6, and 7, articles 5, 6, and 7, the purpose was that they would work themselves out at the commencement of the Constitution. I only want to point out Article 394. If I may read, this article and Articles 5, 6, 7, 8, 9, 60, 324, 366, 367 shall come into force at once, and the remaining provisions of this Constitution shall come into force on the 26th day of January 1950, which day is referred to in this Constitution as the commencement of this Constitution. So therefore, my lords, the 5, 6, 7 sections, articles were supposed to come into effect on 26 November 1949, and therefore at the commencement of the Constitution, therefore by 26 January 1950, they were supposed to come into play for the grant of citizenship. And thereafter, therefore we have said that the purpose of Article 11 was only to add, not to deprive anybody, but to add a certain class of persons which were not covered by Articles 5 to 9. That is the point that I've covered in point 4. I've also given detailed submissions, my lords, which is there already on record. Another judgment that I wanted to add, because Izhar Ahmad, when it discusses in great detail Article 11, it is a Constitution bench judgment. It is very clear on what Article 11 entails, and it has been followed in state of UP versus Shah Mohammad. I have given the volume number and the pages, and also the para 5 of state of UP versus Shah Mohammad. It's a case very similar to Izhar Ahmad, and it follows Izhar Ahmad, and again reiterates that Article 11 is supposed to then come into play for the purposes of the laws to be made for citizenship. My fifth point, very briefly, I have tried to state that Section 6A is not the only statutory provision to be based on a political agreement. And I have given two instances for this. Article 371A, which is the 13th Amendment Act, and it is based on the agreement between the Government of India and the leaders of the Naga People's Convention. Then I've also cited 6th Schedule, which is which is based on the Memorandum of Settlement entered into between the Government of India, Government of Assam, and Bodo Liberation Tigers. And this is now on the autonomous districts and autonomous regions. It covers the areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Then I have just added some case law to say that the classification on the basis of historical or geographical reasons is absolutely valid. And therefore, I have only added the judgment in state of MP versus Bhopal Sugar was already cited before, my lords. I have only added one more judgment on geographical classification, which is Ram Krishna Dalmia versus Justice S.R. Tendolkar. And I have also added Clarence Pai versus Union of India. And in the end, I'm only making a point that if the history of this agitation is seen. It is actually wonderfully spelled out in the Quest for Modern Assam, which is also a part of volume 4A by Arup Jyoti Sakhya. It'll be very clear that what had happened throughout this process and why, because of the Bihar settlers, why, because of the Bengali language, and why this agitation became much more than what the people of Assam could handle. And therefore, for peace and normalcy, the Section 6A was brought about.
Thank you so